and he was being questioned by Mr. Taburin. That's what my notes indicate? All right.
Yes.
All right. And Mr. Thompson, you are still under oath. Mr. Taburin.
Okay.
Yes.
Okay. Thank you, Your Honor. I know we're limited on time, so if I can share my screen, I am going to.
Before you do that, I just want to make sure that there's no personally identifying information on there. If there is,
Only on the exhibit themselves.
if there is, let me know. We can stop live streaming for the period of time that you're showing that exhibit.
Yes, there will be some personnel, their pay stubs and different.
Okay. All right.
Mr. Taburin, do you have witnesses in to lay a foundation for the hearsay documents? Or certificates of affidavits of business records? Otherwise, I'm objecting to the hearsay documents.
No, I don't. I have three of mine that I believe would not be hearsay then.
3 of yours that would what?
Would not be hearsay. I'll attempt to admit.
What's the nature of those documents?
One is my client's financial information form that he signed and we prepared.
Okay.
The second one is actually it'd be 2. The second one is a child support calculation I prepared.
Are you submitting that as a demonstrative exhibit?
Yes.
I wouldn't have an objection to either of those two, Your Honor, to the verified information form. Obviously, Mr. Taburin's client can testify as he was involved in that document and signed it. And I have no objection to Mr. Taburin presenting a child support calculation as a demonstrative exhibit.
All right. I'll ask Ms. Van Oler to stop. Well, first I'll find that it is necessary to stop the live stream because the screen share will show personally identifying information that we don't want to make public. All right, we have resumed live streaming. Mr. Taburin.
And at this point, Your Honor, do you know how much time I have left?
Ms. Van Oler, we won't penalize you for the technical time.
Okay.
Technical issues time.
So it's about 15 minutes, is that fair?
That was right, that's what you started with.
Okay.
So yeah, now we're at, if we take out the technical time, roughly 10.
Okay.
So I couldn't hear that.
Roughly 10.
Okay, I'm waiting for 10 o'clock. Curtis, we were previously discussing the best interest of the child factors. Do you feel, and this is a little bit of recap, but do you feel that the plaintiff throughout this process has supported your relationship with your daughter?
Not entirely.
Okay. And
Mr. Thompson, you need to speak up a little bit.
I'm sorry, not entirely.
Thank you.
okay. Have there been times recently or throughout this process when you have had parenting time that wasn't part of your scheduled parenting time?
Ask them one more time.
Have there been times recently or throughout this divorce process where your daughter was with you when it was not technically your parenting time?
Yes.
Okay. Are there any recent examples of that?
Within this past week.
Okay, can you tell the court, remembering that we're somewhat limited on time, what happened during that incident?
This past Sunday, I was scheduled to drop off my daughter. Her mom was out of town. Her mom texted me and let me know that she was in Chicago and was ill, so that she could not make it back. And she asked me to keep her over until Monday.
Okay, and did you do so?
Yes, I did.
Okay. And so did your daughter return to mom on Monday then?
No, I went to drop her off on Monday, but her mother was still out of town. And then found out after I dropped her off a little bit later that her mother was delayed because of a storm. And then she was going to take up lodging, and my daughter was going to be at home by herself.
Okay, so if I'm correct, you returned your daughter to plaintiff's home, is that correct?
That's correct.
And the plaintiff was not there?
That's correct.
Okay, and at that time, did you leave your daughter there?
Yes, I did.
Okay, and was it somewhat common that your daughter's old enough where she can be home alone for some amount of time?
Yes.
Would you want your daughter home alone overnight right now?
No, I would not.
Okay, do you leave your daughter home alone overnight during your parenting time?
No, I did not.
Okay. So you dropped your daughter off at plaintiff's home. Am I correct then that you later found out the plaintiff was not coming home that night?
That's correct.
How did you find, or how did you learn that information?
When I called my daughter to find out if she had heard from her mom or if her mom had arrived, that's when my daughter told me that she had not, and that her mother had told her that she was going to get lodging and that she would be home in the morning.
And do you recall that was a Monday night?
That was Monday night.
Do you recall what time you talked to your daughter at that point?
About 10:15
PM?
Yes.
Okay.
Something. I told him I was gonna pick her up.
Ma'am, you can't
I'm
speak at
sorry,
this
I
time.
didn't know we weren't muted, I'm sorry.
Yeah, you were muted. I don't know when. There we go.
Thank
Go
you.
ahead,
Aaron.
Mr. Tibiron.
Thank you. So at that point,
Your Honor, I had muted myself because we missed a hearsay objection. When he asked about when he asked about the conversation with the daughter that and so I realized I was muted, so I unmuted myself.
Okay. So you're making that objection now?
I mean, it's fine, but that's the explanation for why I'm unmuted, so that
Okay.
if any more.
Okay. All right.
I could
That's
move
fine as
forward.
that's fine as long as your client doesn't speak.
Understood.
Okay.
Thank you. So Curtis, that Monday night, did your daughter spend the night with you?
Yes, she did.
And that otherwise would have been the plaintiff's parenting time?
Yes.
Okay. Do you recall the plaintiff testifying that your daughter wants more time with you?
Yes.
Okay. Without testifying to what your daughter has said, do you agree with that statement by the plaintiff?
Yes.
You have reason to believe that your daughter does want more time with you?
Yes.
Okay. Did you hear the plaintiff testify that there are currently your daughter has too many back and forths for parenting time?
Yes.
Okay. And do you agree with the plaintiff's statement that right now there's just too much back and forth between the two homes?
No.
Okay. Your request is equal 50-50 overnight parenting time, correct?
Correct.
And you believe that would be in the best interest of your daughter?
I do.
I believe both of you have testified that your daughter is doing well in school, correct? And she's overall doing well in life?
Yes.
Okay. You're confident that she would continue to excel if your parenting time was expanded?
Absolutely.
Do you have any mental or physical health issues that would prevent you from parenting your daughter?
No.
Your daughter is involved in obviously school, but extracurricular activities as well, correct?
Correct.
And if your parenting time was equal to 50-50 parenting time, would you be able to support your daughter in those activities, helping her get back and forth and so on and so forth?
Absolutely.
You heard the plaintiff's testimony regarding some allegations that she made about financial and abuse and controlling behavior.
Yes, I've heard it.
Are those allegations accurate?
No, they are not.
Before you separated, had she made any such allegations like that?
No.
Those all came out after separation?
Yes.
Okay. I believe the testimony was that the plaintiff no longer attends the church where you're a pastor, correct?
Correct.
Was the plaintiff still a member of your church when those allegations came out?
Not attending physically, but her membership was still there.
Did the two of you discuss your relationship or those allegations with anyone involved with your church?
No, not together.
Okay. Have you, again, without talking about what anyone from your church said, have you discussed the plaintiff's allegations with anyone from your church?
Yes,
Were you concerned that by doing so, you would put your employment at jeopardy?
no,
Why not?
because with our denomination within our church, there is a process to help families and marriages that may be fragile. And part of that, if anything was found out to be true, there is a restoration process that happens through the church and through the denomination.
Did you have to go through a restoration process?
No,
Do you believe that you would have had to go through a restoration process if the church believed those allegations were true?
yes.
Objection calls for speculation.
It exposes gaps in cooperation and sets the stage for custody battles.
Mr. Tiburon, you want to restate your question?
I can restate the question, Your Honor. You're employed as a pastor at your church, correct?
Yes,
Have you helped other members of your church deal with similar allegations?
yes,
Did you ever have to make a determination for other people whether those types of allegations were true?
yes.
If you determined that they were true, what would happen?
They would go through a restoration process.
That was something that you would initiate or lead?
No, at the time I was not on the executive team, but I was part of the team to do that.
Okay, but you yourself, have you been through a restoration process yourself?
No, I have not.
Do you recall reviewing a trial brief that I prepared prior to trial?
Yes,
And we made a number of requests for what you want the outcome of this trial to be in that brief?
yes,
Okay. And did you have a chance to review and suggest edits to that brief?
yes,
Okay. And did you have a chance to give a final approval for that brief?
yes,
Are the requests that you made in that brief accurate for what you want the judge to order?
yes.
Okay. I think I'm up against my deadline here, so I, at this point, have no further questions. Thank you.
Right? Mr. Worth?
All right, thank you, Your Honor. Mr. Thompson, the extended parenting time that you had on August 17 and 18, are you frustrated that you had that additional time with your daughter?
No,
All right, so in your mind, then what's the significance of that testimony this morning regarding the 17th and the 18th of August?
I was frustrated with the communication.
Okay, but isn't it true that on Sunday, my client text messaged you indicating that she was having an illness and wasn't going to be able to pick up the child that day?
She did on Sunday, but not on Monday.
Well, on Monday, didn't she communicate back and forth via text message with you all day long?
No, that's not correct.
All right. Well, isn't it true that 11:23 a.m. you texted her saying, "Good morning, hope you feel better. I will drop a pony off at volleyball practice at 3:30 and you can pick her up from there." Do you recall sending her that text message?
Yes, in the morning, yes.
And that was Monday at 11:23 in the morning, correct?
Yes,
And then at 2:15 in the afternoon, she texted you back saying, "I'm feeling better, thank you, but I will not be back in time to get her from volleyball practice." Do you recall her sending you that text message?
yes,
And then you asked her, "What time will you be back? I have a 5:30 appointment and we'll have to possibly set up to stay with someone afterwards."
yes,
And then she responded, "You can just drop her at home. I have an appointment tonight. I will be there around that time." Did she
yes,
text
I
you that?
remember that.
Okay. And then you texted her, she doesn't get out until 5:30, which right now is a conflict in time. Do you recall texting her that?
Yes,
And then she texted you and updated you around 2:30 saying, I will not be back in time to pick her up, correct?
yes,
All right. And then you texted her. I gathered that, which is why I said that arrangements may have to be made for her to stay over with a friend. Do you recall sending her that?
yes,
And then at 4:15, you texted her, turns out my meeting is at 6 p.m. instead of 5:30 p.m. so I can drop her off at home. Do you recall that?
yes,
And she texted you back, thanks. Do you recall that?
yes,
And then at about 8 o'clock, you texted her, how far are you from home? Do you recall sending her that?
yes,
All right. And then is it your understanding that she was caught up in this storm?
that's what she said.
Okay. And do you recall texting her saying, a pony tells me that you are caught in a storm and will be staying overnight at a hotel. So she is staying overnight at home by herself. I'm going to pick her up and we'll drop her off in the morning before work. Do you recall texting her that?
Yes,
And then she responded, thanks. It's pretty bad out here. I'm going to go ahead and check in. I was going to continue the drive, but it's too risky. I was trying to wait it out, but they are saying not to risk it. Do you recall receiving that text message from her?
yes,
And then you texted, where are you? And she responded, just started back up. I've been stuck in Indiana for hours. I was ahead of the storm when I dropped Disha's license off. Then it swept through like mad. It was supposed to hit later, but I had to pull over in Michigan City. It was too bad. It let up, but hasn't stopped. Do you recall her responding with that?
yes,
And then you responded, do you know what time you plan on being home?
yes,
And she responded, you said, do you know what time you plan on being home tomorrow? Do you recall that?
yes,
And she responded, I'll pick her up from Effingham tomorrow. Thanks.
yes,
Okay. Your testimony was she did not communicate on Monday. That, I think we just reviewed an exchange of 10 to 15 text messages between the two of you beginning at 11:30 in the morning on Monday, coordinating what the care of your daughter was going to be.
You asked me what was my frustration, and I said the lack of communication. And for clarification, that's in her notifying me of her intentions to stay overnight. And
I
I
see.
had to learn that through my daughter. That's where the frustration. You're
How old
right.
is-
We
how old is
communicated
your
throughout
daughter,
the
sir?
day. Excuse me, I'm sorry.
How old is your daughter, sir?
Daughter is now 15.
Has she ever stayed home alone?
Yes.
All right. Is there anything unique about your daughter that she shouldn't be home alone as a 15-year-old compared to other 15-year-olds who from time to time stay home alone?
I couldn't hear you. Could you repeat?
Is there something
that?
unique about your daughter that you believe separates her from other children who from time to time stay home alone who are 15 years old?
For a limited amount of time, no.
Okay. Would you agree that that list of text messages could be considered by a reasonable person to sound like a lot of communication and cooperation?
I'm going to object. It calls for speculation.
Mr. Worth?
I'll rephrase it. In your opinion, could that text message be considered to be communication, substantial communication back and forth between two parents trying to coordinate for the care of their child?
I will again object. It calls for speculation on what other people may deem reasonable.
I asked his opinion.
I think he can give his opinion.
Okay.
I think it's reasonable to have communication between parents that give information. I think it's unreasonable at a crucial time not to know that my daughter was spending the night by herself.
Isn't it true that you would filter anything that my client does as not being up to your standard?
Objection, argumentative.
I asked this question. He can say no if he disagrees with me.
I'll allow the question.
Could you repeat, please?
Isn't it true that you would filter any communication from my client as being not up to your standard?
No.
Isn't it true that that's the type of response that my client received during the course of the marriage from you?
I don't understand your question.
Well, isn't it true that throughout the entire marriage, My client tried to communicate with you, tried to satisfy you, and it was never enough.
I disagree with that.
All right. Mr. Thompson, who had control over the finances in the marriage?
Excuse me?
Who had control over the finances in the marriage?
As far as the budget or as far as what?
Let's start with bank accounts. Who had control over the bank accounts in the marriage?
We both did.
And when you say you both did, what do you mean by that?
We both had access to the joint account. And she had her own account and I had my own account.
And when you say she had access to the joint account, you mean her name was on it at the bank, correct?
That is correct.
But as far as being able to access it online, those types of things, passwords were changed, usernames were changed. It was impossible for her to check in on the bank account without going to the bank, wasn't it?
Yes, she could do that.
Mr. Thompson, what is the most money in a single year that your wife ever made while married to you?
I have no idea.
Well, give us a range.
Your question is, what is the most that she has made while we were married?
Yes, in a single year.
I would say that when we were married, when she was working in 2008 or 9 or something like that, I believe she made 60,000-ish or so.
All right. So that was roughly 17 years ago. Your daughter is 15 years old. Do you agree with that?
Yes,
So during the life of your daughter, what's the most she's ever made in a single year?
I have no idea.
Well, do you believe it's more than 60,000?
I have no idea.
Well, in your trial brief and in the child support order that child support calculation that your attorney submitted, and several months ago in a hearing regarding child support, you asserted that my client should be reported as having income of $60,000. Do you recall that?
I can't say that. I don't know.
All right. Do you believe that?
No, I need to object to that question. We just submitted a document that had the plaintiff's income at $42,000.
Do you, Mr. Thompson, that's fine, I'll withdraw the question. Mr. Thompson, what do you believe should be the income entered into the child support calculation for my client?
Are you asking me what do I believe she can earn based upon her background and education and stuff?
Do you believe 42,000 is the correct number that should be used for my client?
That's what we submitted, sir.
Do
That's the
you
least.
believe that's the number that should be used?
That's the number that we submitted. That's the minimum amount that we agreed on.
And sir, what do you base that number on?
The calculations that were submitted.
What do you base 42,000 on?
I believe that may have been the FOC, and I'm not sure if I'm correct. That may have been an FOC recommendation. I'm not sure.
How much did your wife make last year?
I have no idea.
How much did she make the year before?
I have no idea.
You don't review tax returns?
As stated, my wife had a business and she made money and she was LLC. I do not know how much money that she was making.
So for the 2023 year tax return, do you believe that there was unaccounted for money through the course of your wife operating a business?
I have no idea what she made.
How much was reported on your 2023 tax return for how much she made?
Zero.
How about
Because she has an LLC.
how about in 2022?
Zero because she has an LLC.
How about in 2021?
Probably the same, zero, because she has an LLC.
All right. How many members or owners are there in the LLC?
One, herself.
Just your wife, right?
Correct.
And when the IRS looks at a LLC where there's only one member, it's disregarded as an entity, isn't it?
I have no idea.
So whatever net income she would have earned would have been reported on a Schedule C attached to your 1040, which presumably was zero.
If you say so. I have no idea.
Do you prepare your own taxes or you have somebody else do it for you?
I prepare my own.
All right, so you must be familiar with the Schedule C that I'm talking about if you prepared the Schedule C and attached it to your 1040.
My understanding of her situation is that she had an obligation to file her own taxes for money that she incurred and for anything that she paid herself out. I have no idea about anything else in regards to her bank accounts or her deposits or the profit that she made or did not make.
So you did not file 1040s in 2020, 2021, 2022, 2023 that were joint married returns?
Yes, we did.
So what would be her obligation to file a separate 1040?
I have no idea. I'm not a tax expert.
Mr. Thompson, do you agree that your daughter is of an age where she can express a preference as to parenting time?
Yes,
Do you agree she has the maturity to offer good insight and input as to what she thinks her parenting time schedule should be with the two of you?
yes.
Do you have any objection to the judge asking your daughter what her preference is?
No.
All right. Mr. Thompson, prior to going into the ministry, what did you do professionally?
I was a consultant, faith-based consultant and a construction consultant.
All right.
Can you say that? I'm sorry. Can you say that first part a little again?
I was a consultant, a faith-based consultant,
Faith-based.
and a construction consultant.
Okay, thank you. It dropped those first couple of words.
Mm-hmm.
When you were a construction consultant, did you earn more than you earn in the ministry?
No.
What did you earn the last year you were full-time employed as an engineer, construction consultant, whatever that title is?
I was last full-time employed in 2010, and then I became a consultant during that period of time. So I'm not sure what you want to know exactly.
Okay, when you were full-time employed in 2010, what did you earn for the last full year of employment?
I believe in the 90s.
Okay, and that's 15 years ago. Is that correct?
Yeah.
All right. Do you believe that income would have increased had you continued in that field over the last 15 years?
I don't know. That's speculation.
Okay. If in fact that income had increased and was more than what you're earning in ministry, do you believe you should be imputed at what you could be earning had you stayed in the engineering field? Or do you believe that the court should use your current income?
The court should use my current income.
So why isn't that the same thing for your wife? Why do you want to hold your wife accountable to income that she may have earned 17 years ago as opposed to what she presently earns?
I'm not holding her accountable to that.
Well, when you say $42,000, I mean, you agree she doesn't make $42,000, right?
Excuse me?
You agree that you've never seen her make $42,000 in the past 5 years when you were still cohabitating.
I can't verify that.
Well, you prepared the taxes.
I can't, again, sir, I can't verify what she made from her company and what her obligation was to file that. I
Well,
have
you
no
previously
idea.
testified that you were giving her $100 a month so she could get back on her feet. Is that the type of allowance somebody who, does somebody need an allowance if they're earning significant income?
That was when we were in transition and she was a startup over about 13 years ago.
So when did you stop the $100 a month?
When she left the home.
Your Honor, I would note that we're at about 17 minutes now of cross. I believe we've exceeded the timeline we were given prior to trial today, resuming.
Sorry, Judge, what was the decision on that?
Ms. Van Oler?
Yes, attorney work started at 10, attorney interviewing ended at 10.
So yes, we're at 18 minutes.
So I'm over my
As of
time.
now.
All right, thank you.
All right. And just out of fairness, Mr. WRN, do you have any brief direct.
Just very quickly, Your Honor, Curtis, involving the last Monday that you testified about when your daughter came back to spend the night with you,
Yes,
your frustration was not the communication throughout the day, correct?
it was not.
Was your frustration due to the fact that your daughter was going to be left home alone at plaintiff's home without you having been notified?
That is correct.
Did the plaintiff notify you specifically that night that her plan was to leave your daughter home alone?
No,
Did your daughter inform you that that was the plaintiff's plan?
yes,
And that was your frustration?
correct.
Thank you. No further questions, Your Honor. Thank you.
All right. As I had indicated at the last hearing, written closing arguments are due September 3rd at 5. Is that date still doable for the two of you?
I guess my only question would be, we've agreed to, I think, request an expedited transcript. I don't know how long that will take.
Out of fairness to everybody, I think that would require work over the holiday weekend, perhaps. So maybe we should change that date, unless somebody has an objection to that.
I don't have an objection.
I don't object.
And I don't want to have the parties incur that expedited fee.
Okay.
All right. So
Could we
Look at
set
the
it for
calendar.
like 1 week after we get the transcript?
I can't think of any reason why that wouldn't work.
Here, the cross-examination turns fiery as lawyers press about money.
10121 DM. Both parties are present. Plaintiff represented by her attorney, Christopher Worth. Defendant represented by his attorney, Michael Tiburon. We are here for a divorce trial in this matter, and it's my understanding that the defendant has some preliminary procedural matters that he wishes to address.
Yes, thank you, Your Honor. I would ask the court to note that there is a scheduling order in this matter that required briefs to be filed at least a week before trial. I received plaintiff's trial brief and exhibits Friday, just 3 days ago at about 3:00 p.m. I did file defendant's brief in May prior to the original trial date. We stand by that brief. That brief has been on file for 3 months. I would also note that I did send over some additional potential exhibits this morning. That was merely in request to, or in response to plaintiff's request for some additional information that they thought might help settle this case. Those were not exhibits that I otherwise would have moved to admit, and I don't know that I will move to admit them. I would note that parenting time is a contested issue. Plaintiff's trial brief does not include an analysis of the best interest factors. Child support is a contested issue. I don't have I don't have any income information from plaintiff in their exhibits other than what they used in their proposed child support order. Spousal support is a contested issue. I think income would certainly be sufficient or be necessary on that issue as well. I would ask the plaintiff not be allowed to present testimony or evidence based on their failure to follow the scheduling order. I normally would meet with my client and review the opposing party's brief, which I have had very minimal time to do because we received it late. I would note that this trial was adjourned 3 months ago at plaintiff's request because she hired a new attorney. I would, at a very minimum, if the court allows plaintiff to testify and present evidence, I would ask the court to use for her income, the income from the friend of the court recommendation, because we don't have income information from plaintiff. But again, I would ask the plaintiff not be allowed to testify or present evidence, as I think it is extremely unfair to my client and has made kind of our final trial prep difficult. So again, and I would again note that our brief has been on file for 3 months. I did email a courtesy copy last week to Mr. Worth and to your clerk, but that was no different than what was already on file. Thank you.
Mr. Worth?
I think Mr. Tiburon's position reflects the fact that they can't support their positions in this case on the merits. I think it's important to know Mr. Taborin wants to rely upon a trial brief that he submitted back in May. 4 months later, here we are. He did not submit a trial brief with updated exhibits, updated positions, updated income, any of those matters whatsoever. To the extent that he did submit a trial brief, it was the one from May, and he just re-emailed it to the court and to me on Wednesday. I think if Mr. Taborin felt that that was sufficient, that he had filed that trial brief back in May, he wouldn't have felt compelled to then email it on Wednesday. So I would submit that neither side has been fully compliant with the scheduling order to have it in 7 days in advance. There's no dispute that Mr. Taborin did receive our trial brief. Our trial brief consists of nothing different than Mr. Taborin and I have been discussing being my client's position in the case, and her position in the case hasn't changed since the parties attempted to mediate before I came on the case. So it's consistent with everything that plaintiff has said that she was requesting in this case, in the same way that Mr. Taborin wants to rely upon a brief that he filed back in May. With respect to income, my client absolutely should be able to testify to her income. We haven't produced exhibits with respect to her income because she's self-employed and frankly, she doesn't have them. So, you know, we're not intending to present the physical exhibits, but her testimony certainly can be presented today. Mr. Taborin's going to have an opportunity to challenge her on that. Our position with parenting time is the exact same parenting time schedule that the parties have been exercising throughout the duration of this case, which aligns with the best interest considerations that were identified in the friend of the court report recommendation. So that's all been set out before. So if Mr. Taborin wants to rely upon his trial brief, that's 4 months stale, we ought to be able to rely upon what our positions and positions of friend of the court has been in here. Look, we didn't offer an analysis on the custodial best interest factors because my understanding is the parties don't dispute that. They're both asking for joint legal custody. So I don't think we need to spend any time on the aspect of the custodial best interest factors. It's clear the custodial environment is with my client. She can testify to that. Mr. Taborin can challenge her on that. His client can take a different position on that. But the request to somehow prevent my client from testifying on these matters when it's been clear throughout the entire case what her position is on it, I think just is Mr. Taborin's last-ditch effort to try to get his client's position when they can't really support it based upon what's transpired over the past 14 months. The other issue, Your Honor, is Mr. Taborin wants to point fingers at my client with respect to being timely with exhibits, timely with disclosures, and therefore muzzle her this morning. But Mr. Taborin's client has his own warts when it comes to turning things over and being timely with discovery. There were timeshare properties that were not disclosed. There was the Wesleyan summary plan, the church's pension plan that he's a part of that was not disclosed. There were other benefits summaries and statements that were not disclosed. These are all things that he was obligated to turn over to plaintiff all the way back to the days of the verified financial information form and failed to do. Mr. Taborin himself told me that it was just this week that he discovered from his client that there was the existence of a timeshare property. So, you know, I understand Mr. Taborin wanting to basically play the game this morning with one team not taking the field. But he's got his, you know, what's good for the goose is good for the gander. Let's either try this thing on its merits, continue it so that both sides meet that 7-day requirement with respect to a trial brief and actually get a trial brief from Mr. Taborin that's not 4 months old, and be able to have an opportunity to get further disclosure on these timeshare things and that matter. But I think not allowing either party to proceed on the merits of the case this morning with their presentation just goes entirely too far given the conduct of Mr. Taborin's side of the case.
Mr. Taborin?
There's no disputing the fact. Our brief is on file. The plaintiff's was not on file till Monday. The timeshare, I believe, is a resolved issue. It's a red herring. The court issued an order. And I would go back. We followed the order. Our VFIS were filed months ago. Mr. Worth mentioned my client's retirement account. It's on his VFIS. It was labeled as a pension, so Mr. Worth questioned whether it was a defined benefit or contribution plan, but My client and I discussed that. We discussed that with the prior attorney months ago. The bottom line is plaintiff didn't follow the order. They're scrambling, trying to find a way to defend it. I'll leave it, to the court's discretion, obviously, but the brief was filed Friday at, I think, like 3:07 p.m. was when I got it via email.
All right, thank you. The scheduling order is very clear. Briefs are to be filed at least 7 days prior to trial. It is clear that the defendant did comply. There's no requirement in here that briefs be updated. I've got the order right in front of me. And the other thing that's very clear in my scheduling order is that any witnesses or exhibits not identified and exchanged according to the scheduling order may be excluded from evidence at trial. And any exhibits that were submitted to the court or witness lists that were not received by the court for either party before 7 days before trial are excluded. Now, the parties can certainly testify, but any witnesses that were not disclosed prior to that cannot. And as I said, no exhibits can be admitted that were not submitted to the court prior to 7 days before trial. The other thing I need to indicate, it also talks about trial limits, time limits. It doesn't specify in here. I usually do, but it does indicate and does give the parties notice that the court will impose time limits. And for a case such as this court typically assigns an hour and a half per party. So there's no businesses really. I know that the plaintiff is self-employed, but at least the gist that I get is not that this is, I don't know what the word to use, substantial employment where there would need to be significant evidence presented. The front of the court recommendation was provided to everybody months ago. So obviously that is something that the court can take a look at. But Ms. Van Doller will keep track of time and we'll get started. Do each of you want to make additional opening statements? You kind of did just now, but.
Your Honor, if I could just clarify, when we talk about 1.5 hours, how do we factor in cross-exam on that?
It counts. If you look at the scheduling order, there's an example in there.
Okay.
Plaintiff's total time includes plaintiff's opening statement, plaintiff's direct and redirect, cross-examination of defendants, witnesses, and plaintiff's closing argument.
Okay, so it's okay.
Okay, Mr. Worth.
Your Honor, for purposes of clarification on witnesses, typically, even in trial briefs, the parties are permitted to reserve rebuttal witnesses. I suppose for rebuttal purposes, your position does not apply this morning.
Correct.
Thank you. All right. I'll waive opening. I think the parties' positions are clear.
Likewise.
Okay.
So I'll waive opening in order to save time and start with my first witness, who will be my client.
Okay. And ma'am, would you raise your right hand? Would you state your name and spell it for the record?
Meoshia Nachi Thompson, MEOCHIA, and then Nachi NOCHI, and Thompson THOMPSON.
And do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you, Your Honor. Mrs. Thompson, you are the plaintiff in this lawsuit, correct?
Yes.
All right. And so at some point you filed for divorce?
Yes.
And who did an attorney assist you in that filing?
No.
Did you later obtain an attorney?
Yes.
And was that attorney through legal aid?
Yes.
And then at some point in April, did you request that I come on the case in the place of the legal aid attorney?
Yes.
All right. Now, when did you meet Mr. Thompson, the defendant in this case?
I met him in 2006.
And when did you marry?
2008.
All right. Now, at the time that you met Mr. Thompson in 2006, did either of you have children?
Yes.
And did both or just you?
Both.
Both. And how many children did you have when you met Mr. Thompson in 2006?
One.
One. Male or female?
Female.
All right. And what was her age when you met Mr. Thompson?
She 11, going on 12.
Okay. And how about Mr. Thompson? How many children did he have when you met?
3.
3. And what were their genders?
2 females, 1 male.
Okay. And what were their ages when you met?
They were 8 and 9.
And how about the third child?
Oh, I'm sorry, they're twins. The twins were 9.
Oh.
And the baby girl was 8.
Okay, so he had one set of twins who were each 9 and then an 8-year-old.
Yes,
Okay. And then you married 2 years later.
yes,
All right. At the time that you married the 5 children, those 5 children, or 4 children rather, your daughter and Mr. Thompson's 3 children, are they all now adults?
yes.
Okay. And what are their adult ages?
My daughter is 30, and then baby girl back then, she's 27, and then the twins are 28.
Okay. And then is there a child that is part of this marriage between you and Mr. Thompson?
Yes.
Okay. And what's that child's name?
Her name is Neoshia Apani Thompson.
Okay. And when was she born?
She was born August 20th, 2010.
And how old is she now?
She's 14, she'll be 15.
Okay. And you and Mr. Thompson were married at the time of her birth?
Yes.
Has there ever been any doubt for you that she's Mr. Thompson's biological child?
No.
Has he ever questioned whether or not she's his biological child to your knowledge?
No.
Okay. When you were married, where were you married?
We were married in Chicago.
In Chicago, in the state of Illinois?
Yes.
Do you recall which county that was?
Cook County.
Cook County. And what was the specific date of the marriage?
August 16th, 2008.
All right. And at some point, did you marry in Chicago because that's where you wanted to have the ceremony, or were you living there at the time?
That's where we wanted to have this ceremony.
Okay. Where were you living at the time of the marriage, of the wedding?
We were in Flossmoor. I had just ended my lease. And we were in Flossmoor, Illinois. So I lived in Chicago before.
So you were both residing in Illinois at the time of the wedding?
Yes.
Okay. And then at some point, did you relocate to Michigan?
Yes.
Okay. When was that?
That was around 2015, I believe.
Was that 2015?
Yes.
Okay. And where did you relocate to?
To Kentwood, Michigan.
Kentwood, Michigan.
Mhm.
So since 2015, have you been living have you been living together in the state of Michigan
Yes.
and in Kent County?
Yes.
Okay. Now, with respect to your daughter, what is your position on legal custody?
I have to make sure I get these right. Legal custody, I don't mind if me and him share legal custody.
Okay. What is your understanding of legal custody?
Legal custody means like major decisions with her, as far as like, I'm not sure if it means like doctors or things like that, but if anything major happens to our daughter, if she is in a car accident and maybe needs a transplant or something like that, we would come together and discuss that.
Okay.
How we'd like to proceed.
So is it your understanding, for by way of hypothetical, that if there was a major medical decision that needed to be made regarding your daughter, you and Mr. Thompson would have to agree to that decision, otherwise file a motion with the court and ask the court to decide?
Yes.
And that might be different. Is it your understanding that might be different than if your daughter had a stomach ache one morning and needed to go be seen by the doctor, or fell off a trampoline and broke her arm and needed to be taken to the emergency room?
Yeah, I would think that would be different.
Okay. And is it also your understanding that selecting doctors, mental health professionals, starting new courses of treatment like counseling or therapy would fall under the joint legal custodial decision making?
No, I wouldn't think that would fall under legal custody.
All right. If it does that change your position on on legal custody?
Yes.
Okay. So describe what your understanding is and why that would change your position.
It would change my position because I am the one that takes her to the doctors, to all of her appointments. I'm the one that picks her doctors. I always have been. She was working with a therapist at school. I had to sign for that, and for her to even have a therapist now, I'm the one that had to sign for that. I take her to her appointments all the time, everything that goes on with her. I'm normally the one that is there with her and takes her to those places. Mr. Thompson does not.
So historically, you view yourself as having been the primary caregiver on those types of decisions and
Yes.
appointments and the logistics of getting her there and the follow-up up to those appointments?
Always, even when I worked, always it was me. He didn't do it.
Okay. Now, do you have concerns that if Mr. Thompson had an equal voice in making those decisions, that would have some type of negative impact upon your daughter?
Yes.
Okay. Can you describe what that would be?
I think that the time frame that, for one, he doesn't know any of the information about her as far as like her doctors and things like that. When I'm sorry, my mind is like kind of racing. When I ask him to make certain decisions, he can't make it because he's working. He does not allot the time. So I'm usually the one that has to take off work or stop whatever I'm doing to make sure those things are done, and he is not. So if she needed some type of care like that, I'm the one that has relationships with our doctor. And I would just feel more comfortable with me doing it rather than him, because he doesn't have relationships with any of them.
Now, when you talk about him, not needing, or that he would or would not take off work, those types of things, are you speaking to the logistics of getting her to appointments and attending appointments, or are you speaking to the ability to discuss major decisions that need to be made and resolving at a decision together in a productive way?
Yeah, even when it comes to making decisions in a productive way, it normally takes him a while, and sometimes it takes more time than necessary. So things end up last minute. And when Mr. Thompson gets certain information, he does not share it with me. Even when I ask, he does not share it with me, but I'm more open and apt to share things with him, especially when when I'm talking about with us and our child.
Okay. Now, as it relates to decisions about where she attends school, do you think you and Mr. Thompson agree on that?
Yes,
And what year is your daughter in that school?
she's going into her sophomore year.
Sophomore year. So she should have about 3 more years of school.
Yes,
Do you believe that you and Mr. Thompson agree that she should continue in her current school?
yes,
All right. To the extent that there's other decisions that arise for her education, do you think that you and Mr. Thompson can reach agreement on the decisions that need to be made?
yes,
Okay. And is it your understanding that making those types of decisions is part of joint legal custody?
yes. Sometimes I have concerns.
Okay. What concerns do you have?
Well, I wanted to put her in a camp before, because she needs help. Her school is kind of limited in sports, and I wanted to put her in a camp. And Mr. Thompson basically did not want to help pay for those camps. It was things that would make her better in the sport, because her schools, they don't have, they're not equipped to kind of like get her the training that she needs.
Okay.
And so,
So would you describe the camp as being a part of the school, or would you describe the camp as being an extracurricular?
it would probably be an extracurricular.
Okay. Was that extracurricular camp going to impact Mr. Thompson's parenting time schedule?
I don't think so.
Okay. Now, with respect to her religious upbringing, do you believe that you and Mr. Thompson agree on what her religious upbringing should continue to be for the next 3 years, or do you think you're unable to agree on those things?
No, I think we agree on that.
All right. So is it fair to say your primary concern as it relates to legal custody is in the realm of medical,
Yeah,
physical, mental health, and dental health?
yes,
Okay. And is it accurate that your primary concern relates to Mr. Thompson's timeliness in participating in the communication so that the timely decisions can be made for your daughter? Is that one aspect?
that's one aspect.
And that the other aspect is that he, in your opinion, he does not share information with you that would be important and significant to that decision-making process. Is that the other aspect?
Yes,
Okay. Any other concerns regarding legal custody?
no.
All right. Now, what is the current parenting time schedule that you and Mr. Thompson have been exercising in this case with your daughter?
We have been exercising every other week, Thursday to Sunday. And
And so Mr. Thompson has your daughter every other Thursday through Sunday?
yes,
All right. And where does he usually pick her up, or what time does he usually pick her up on Thursdays?
so Thursdays he'll normally pick her up after school if school.
Her refusal of equal say sparks a powerful debate on custody rights.